Good morning, Your Honors.
Good morning.
John Stevenson here from the Shelby County Bar. I represent the appellant, Jeff Smith, in this matter, and I'd like to reserve 4 minutes.
4 minutes. All right, sir. You may proceed.
This case emanates from an order granting partial summary judgment, and it set aside a quitclaim deed on the basis of undue influence. And that quitclaim deed was from the decedent, Janice Smith, to my client, her son, Jeff Smith. The appellant asserts that the trial court erred in granting summary judgment, that it was an appropriate decision to go to trial, that there were genuine issues of material fact and dispute, and then my client also alleges that the Rule 5402 certification of the order was improper. As a brief underlying background of this case, this is a dispute between two brothers over their mother's estate. And the appellee, Don Smith, is suing his brother, the appellant, Jeff, alleging numerous transactions should be set aside on the basis of undue influence, not just the quitclaim deed that is the subject of this order that is appealed here today. And now that undue influence arises from a presumption due to a power of attorney that was exercised by my client, Jeff. The power of attorney named him and Don as attorney in fact for his mother. It's undisputed that presumption arose, and the trial court that led my client led him in a posture to try and rebut that presumption by showing by clear and convincing evidence that the quitclaim transaction was fair under the circumstances, or as it has been described, was the free and independent intent of the decedent is really the inquiry. My client submits that
there's no question about the presumption arising. The only question is whether you rebutted the presumption. Is that?
That's correct, Your Honor. Yes, at the summary judgment stage. So my client rests on several things that are in the record which could indeed show that the transaction was fair. I'll name 5 while we're here that I think altogether or even independently are things that should have been before for a trial, not for summary judgment. Summary judgment is not where we weigh the evidence, the strength of the evidence, where we determine credibility. Those matters are to be determined at trial. The first one is the existence of a family agreement that is evidenced by affidavits in the record, including the party's sister, Janice Smith. A family agreement that Jeff, after he lived with his mother, along with his immediate family for almost 10 years, taking care of her, that after 5 years he would receive the house as compensation for him foregoing his time and employment to care for his mother. That's remarkable because that's against Janice's pecuniary interest. She supports the quitclaim deed and affirms that this agreement existed. Were it not for the quitclaim deed, if it were set aside, she would indeed receive 1/3 of the house as a beneficiary of her mother's estate as well. Jeff moved in with his family almost 9 years. You know, he lived with his mother and his family and took care of her. He maintained the property. He paid for internet, property taxes, the alarm system, homeowners insurance.
Did he pay for all of those out of his own funds? I wasn't clear about that.
He did pay for some of those out of his own funds, yes, Your Honor.
Taxes on the property?
He did pay taxes on the property as well.
Does everyone agree that this agreement existed?
Well, it is in dispute. The appellee disputes that the agreement existed. However, the appellant and his sister agree that that it existed.
So 2 out of 3 of the people agree that this was an agreement?
2 out of the 3, it's a disputed fact, which, should not be decided on summary judgment. Respectfully, it's something that should be weighed at trial when the evidence is more fully developed, someone's on the stand, and their credibility can be determined. I would move along and say the third point is in 2018, prior to this quitclaim deed being executed, she met with her own attorneys at Williams McDaniel, attorneys that had prepared her estate planning documents previously. The will that was admitted to probate, the power of attorney, she went and she met with them. That's in the record. There's a letter from Williams McDaniel in response to a subpoena that evidences that she went and she met with her attorneys. It can be inferred that she spoke with them about her estate planning, that she potentially spoke with them about...
How can you infer that at summary judgment?
Well, everything is supposed to be inferred in the light most favorable to the respondent, the non-movement, which in this case is Jeff. And again, this is just one of several factors. She made her own arrangement for the execution of the quitclaim deed. Her own arrangement, she filled in the legal description on the quitclaim deed. She had Jeff take her to her bank and have it notarized in public. That occurred. There's a holographic codicil as well, which purports to leave the house to her son Jeff. That has not been submitted for admission to probate. It's been appellant's position that property was deemed by the quitclaim deed, but it still demonstrates the intent of the decedent that her son receive the house. And this all goes to show that
if it hasn't been submitted to probate, the holographic codicil?
It has not.
And so I'm trying to ascertain the evidentiary value of that.
It goes to show the free and independent intent of the grantor or the decedent, which goes to show the fairness of the transaction.
For some reason, it hasn't been submitted to probate?
It hasn't been submitted, Your Honor, because there's no need to submit it. It only discusses the real estate, which was deemed by the quitclaim deed.
Assuming, though, the quitclaim deed is not valid, as the trial court ruled.
Well, then the codicil very well may be submitted for admission to probate.
I'm just curious why it hadn't been submitted.
Well, it would be of no consequence if the deed itself were valid. And we have not had an opportunity in the trial court to go any further. We've been resting on the quitclaim deed for the transaction, the conveyance of the real estate up to this point. So for purposes of the summary judgment, the codicil really only goes to bolster the intent of the decedent, the grantor.
Was the codicil signed?
It is signed at the top, Your Honor. There is a signature at the top of the document. It was definitely a homemade, handwritten codicil, holographic codicil.
Is it in her handwriting?
It is, Your Honor. There's no
dispute about that?
Well, I believe that there may be a dispute about that, but it has not been decided by the trial court. It has not been put before the trial court as a testamentary document because the quitclaim deed deemed the real estate.
Was it submitted to the trial court in conjunction with this summary judgment motion?
It is in the record for purposes of the summary judgment, Your Honor.
Back in this 2018 visit with Attorney Malin, I think that's his name. Was there any evidence in the record that she met with him individually? I know the son was also, your client was also there at the time that they met with him. Did he give an affidavit or any declaration or anything indicating that he met with her?
The attorney from Williams McDaniel did not, Your Honor, and this is not in the record, but this has been many years ago. He's moved on. He works at a different firm in Nashville, so that he was not able to obtain any meaningful evidence to put into the record from him concerning those meetings.
So there's no proof in the record that she sought advice from independent counsel about execution of the quitclaim deed. Is that right?
Not precisely concerning the quitclaim deed, but that she did meet with her attorneys twice at Williams McDaniel in 2018 prior to the quitclaim deed being drawn up. Yes.
But under the terms of the will, that property would have been shared with all of her children, not just your client. Is that right?
That's correct. All three of the children didn't move in with her and care for her for 10 years, as did he and his family, Your Honor. But yes, that's correct. Under the terms of the will, it would have passed to all three of them.
Okay.
I'm almost out of time, so I'm going to have to reserve my 5402 argument for my rebuttal time. But I would just say that this is, not proper for adjudication on summary judgment. There is evidence in the record that could be looked at and that could go to show that it was fair under the circumstances. The transaction, those 5 things that I named working together, that it was the free and independent intent of the grantor. And this is something that should have been decided upon trial, not summary judgment.
Thank you.
Good morning, and may it please the court. My name is Jared Eastlack, and I represent the appellee plaintiff, Mr. Donald Edwin Smith, who is the personal representative of the estate of his mother, Janice N. Smith. I would like to start my presentation by addressing the Rule 5402 subject matter jurisdiction argument that appellant's counsel referred to, because to the extent that there is a subject matter jurisdiction question for this court, that would need to be resolved before the court would make any rulings on the substantive issues related to the summary judgment motion. And as I understand the arguments of the appellant on the Rule 54.02 certification issue, the central question is whether the claim and request to set aside the quitclaim deed arises out of the same set of operative facts as the other claims in the complaint. Our position is that it does not, and it has a very distinctive fact pattern, different from the other financial account transfers that have been challenged.
What makes it different? Is it because it's real property
So
and not cash?
That's one of the reasons, Your Honor. So it is real property. It's the only piece of real property involved. The other financial transfers that we've sought to set aside total around $135,000. It's over 200 transactions. Most of them are small, less than $1,000, but some are larger. The residence itself is the only real property, and it was the largest asset in the decedent's estate, worth approximately $225,000 to $250,000. So it is.
Why does that make a difference?
Well, it makes a difference because the inordinate size of the real property conveyance sets it apart from some of these other smaller improper transactions. It is a disproportionately large transaction, and it is real property. It also involved the
But under the rule, why does that make a difference under the rule?
So under the rule, it would.
Is it a separate issue?
It makes a difference because if we're looking at it through the lens of whether it arises out of the same set of operative facts, the question is, what are the facts that the claim relies on? So the facts that the quitclaim deed conveyance is based on include the meeting with Attorney Malin. That doesn't concern any of the other transactions. So the position that they have maintained is that she met with the attorney to discuss this real property conveyance and received independent advice. Now, none of the other transactions are related to that fact.
As I understood it, there is no proof in the record that she met with the attorney and got independent advice concerning the quitclaim deed. I mean, where are you getting this argument?
So
She met with the attorney and got independent advice.
So there is no proof that the advice was independent. There is proof in the record that she and her son Jeff, the defendant, the appellant, met with Attorney Malin on 2 occasions. And there is proof that Attorney Malin discussed the case with Jeff. He's admitted that. So it was not independent advice because Jeff took her to the attorney's office, he was present with her, and he, the donee, discussed the case with the attorney, so the attorney was not independent.
Did he testify that she met with the attorney separately?
Did who testify, Your Honor?
Did Jeff?
No. Jeff has not offered any testimony that she was alone with the attorney. He hasn't even filed a simple affidavit to that effect, which I think is telling. But even if...
Aren't we kind of locked in by what the trial court found, which is decedent did not receive independent legal advice concerning the quitclaim deed conveyance?
So the decision of the trial court is reviewed de novo by this court.
We don't have a transcript of the proceedings, do we?
So there is no transcript of that proceeding, Your Honor. The only information that would be available to the court would be to review the record evidence that's already in the record to determine if the ruling that she did not receive independent advice is consistent with that. Of course,
Well, really, isn't that just a review of the undisputed material facts submitted by the parties to determine whether summary judgment's appropriate?
So it's our position that she didn't receive independent advice and that the trial court got that correct. But that is just a fact that is distinctive about the real property transaction. Another fact is that the deed was prepared, it's a handwritten deed, and it was prepared by, allegedly by the decedent and Jeff together, and he assisted her with that. He transported her to have it notarized. He took the deed to the registrar's office and recorded the deed. It's another fact that's distinctive and related to only the quitclaim deed conveyance. It's not shared in common with any of the other transactions. And then the other distinction that I think is important is that the will leaves the real property to the estate, invests title in the real property directly in the personal representative, and directs that the real property be sold by the personal representative. And then the residuary is split in thirds, 1 share to each child. And the quitclaim deed conveyance is at variance with the will of the decedent. And so the quitclaim deed is inconsistent with the testamentary intent that the decedent expressed in her will.
What was the date on the will?
The date on the will was 2006, Your Honor.
That's before Jeffrey moved in with her?
It is, yes, Your Honor. And in evaluating the other items of purported evidence that were offered,
Is the person that drafted the will the same person that she subsequently saw?
No, Your Honor. The attorney at Williams McDaniel that drafted the will was an attorney, Andrew Carter, and the attorney that she met with at Williams McDaniel in 2018, that she met with on 2 occasions with Jeff, was attorney Rob Malin, who's now in Nashville. He's no longer with Williams McDaniel. The other distinctive evidence that relates to the quitclaim deed conveyance that doesn't really relate to the others is the presence of a so-called family agreement and the so-called codicil, which were offered during the appellant's presentation as evidence that the court should consider and should, should have waited to make a determination until trial, that it should not have granted summary judgment on the basis of that evidence. And I think that it's our position that neither the family agreement, so-called, in the Janice affidavit or the codicil document are admissible evidence. But even if they were admissible, they don't show the fairness of the transaction. So in order to show the fairness of the transaction, even if they were admissible, there's a problem first with the Janice affidavit, because if the agreement was reached in 2017, assuming that's true, that he was to receive the house after 5 years of service, then the 5 years of service would have come due in the year 2022. Instead, the quitclaim deed conveyance occurred 18 months later, in the year 2018. So if she believed, the decedent believed, that it was fair for him to receive the house after 5 years of service, then there's all of a sudden a quitclaim deed conveyance 18 months later. That's, it wouldn't support the fairness of the transaction by clear and convincing evidence. And the codicil document is also problematic because even if it were to be admitted, it's a very strange document. But the codicil document is undated, so if it was done before the will occurred, it would have been revoked by her will. And if it was done after the quitclaim deed conveyance occurred, it would suggest she didn't know that she had already conveyed the house to Jeff in the quitclaim deed conveyance.
Let me ask you a question based on what you were just saying about the 5 years and whatnot. At the time that this agreement allegedly occurred, hadn't Jeffrey already been living with her since 2011?
He had.
So it was 7 years by then.
It was, and so if it was if it was the decedent's position that after 5 years of service he should receive the house, he would have already gotten it in 2016. There would be no reason to do a new agreement in 2017 for 5 years of service. But as I read the affidavit that's been submitted by Janice, it suggests that in 2017 they made an agreement for him to receive it after 5 years.
Well,
but
is there any testimony that there was ever an agreement before that?
No, and again, Don Smith disputes that so-called family agreement ever existed.
Well, these all sound like disputed facts.
But and there is the sense that these, all of these pieces of evidence, potential evidence, are in disagreement. I mean, they don't agree with one another. But assuming that all of them were introduced, the family agreement says you get the house after 5 years, which would be 2022. The codicil says you would get the house after I die. The will says you don't get the house at all. It goes to the estate, and it's split 3 ways. And then the quitclaim deed gives it to her.
Excuse me, this 2022 that you keep bringing up, was that ever part of the agreement? I mean, it was 5 years.
It's 5 years.
5 years. And he'd already been living with her for 7 years at that point.
He had been living with her since 2011.
And this
So
was 17, 6 years.
that's right. So it had been 6 years.
Well, help me here, because I've gone back and tried to read the order granting summary judgment. And the order granting summary judgment doesn't even mention this agreement or the codicil. Would that be accurate?
It does not, Your Honor.
So I'm assuming, was this information, the codicil and the agreement, before the trial court?
All of the codicil and the affidavit were both presented to the trial court and were before the trial court in.
As what, undisputed material facts or what?
As disputed facts, Your Honor.
I'm not real sure how this process worked. It seems a little unique to me from summary judgment.
So I think what the court did, though, is look at all the facts in the record, including the potential Janice affidavit as evidence of the family agreement and the codicil agreement, and determined that there was no way, even with that potential evidence, that he would be able to show the fairness of the transaction by clear and convincing evidence under that standard.
Okay. So essentially all we've got is, we've got your statement of undisputed material facts, we've got opposing counsel's statement of undisputed material facts, we don't have a transcript, and we've got the trial court's order. Is that right?
That's correct.
Okay.
And we also have 8 other pending claims between these parties, is that right?
We do. We have other claims that are pending, and
And so you think we ought to have some piecemeal review of all of this? Review this part now, and then later, what do we do?
so I don't believe that this will result in piecemeal litigation. The resolution of the specific claim on the house will allow the estate to sell the house and administer the house in the estate. It will not affect the other claims. The factual basis for the quitclaim deed conveyance is separate and distinct from the other claims. Judge Gomes determined that it was proper to certify it as a final judgment. The certification of a final judgment allows the estate to sell the real property to a buyer, because there's no concern that the order would later be set aside on appeal at a future date down the road. And Judge Gomes made an appropriate decision. It's supported by the record, and we submit that the court should affirm the decision of the trial court.
Let me ask you one question in relation to that. Probate is somewhat unique, and it's very difficult as far as finality of orders sometimes to ascertain what has to be appealed and what can wait until the probate estate is actually totally resolved. Is this one of those issues that you believed was required to be appealed, or it would be waived, or become a final judgment?
Yes, Your Honor. It would be our position that even if the court had not included the Rule 54.02 certification, that it would still have been final as to this claim. I think it's the better practice to include it, so there's no question about it among the parties, and Judge Gomes agreed and included that in the order, and I think that was appropriate to certify it so there wouldn't be any question about it.
So this is more of a belt and suspenders approach then. You believe this was a final judgment, but also in order to substantiate the finality itself, you followed Rule 54.02.
We did, Your Honor.
Okay.
Let me ask you, can you cite us to a single probate case that says that a case like this is one that should be appealed or has to be appealed within 30 days? And we all understand that in probate matters, there's some claims, if they're denied or granted, you have to appeal. Will construction, you have to appeal. But what is it about this that would indicate that it has to be appealed within 30 days?
So the fact that it fully resolves this particular claim as to the action to set aside the deed in this case and leaves nothing else for the parties as to this claim.
This is not a distinct party. These are the same parties that are involved with all of this property, is that right?
That's correct.
There's no third party out there.
No, it's this.
If this had been something involving a third party, then that would have been immediately appealable, right?
That's correct.
But this doesn't involve a third party. It involves, all of the property involves the same three parties.
That's correct. It involves the same parties, but different claims. And so, under Rule 54,
Maybe different property, maybe, personal property, real property, but it all involves the same parties and the single estate.
that's correct.
Thanks.
Thank you.
Well, there has been much discussion about the Rule 5402 certification, which I did not get to address in my first time to speak to the court. And I just want to touch on that briefly and want to make sure to make mention of the Carr case that was cited to the court, which is remarkably similar in both its factual and procedural course. It is to a motion for some partial summary judgment that was granted at the trial court to set aside 2 transactions out of many that were challenged. And the court certified it under Rule 5402 and sent it to the Court of Appeals. And the Court of Appeals determined that, yes, that did not, in fact, adjudicate a claim, a single operative of facts, and that it was all part of the same claim, although there were many transactions that were sought to be set aside. Those transactions were all part of the same operative set of facts. And I think one thing that has not been mentioned that's being lost is, while this quitclaim deed transaction is concerning real property, and that is a distinction from the Carr case, the great similarity is the posture in which the non-movement, the appellant, my client, and the person in Carr were in, where they are going to have to turn to the same evidence to show that the transaction, all of the transactions, were fair under the circumstances. Yes, were there some things that are unique to the quitclaim deed? There are, but let's not lose sight of the almost a decade-long of service that he spent caring for his mother and sacrificing. That goes to both. That goes to all of the transactions.
Is the confidential relationship undue influence claim effective as to the remaining claims between the parties? Does it relate in any way?
My understanding of appellee's position is that it's some of them. So they have alleged there was undue influence prior to the exercise of the presumption of the power of attorney that gave rise to the presumption of undue influence. But they're alleging that
the specific undue influence claim here, based upon the exercise of the power of attorney, does it relate to any of the other claims?
It does. It does relate to other transactions, financial transactions that occurred after the exercise of the power of attorney. They're all.
Wasn't there a Regions Bank issue about setting up a separate account? Or?
That's when the power of attorney was exercised. But there's an allegation that there were other transactions prior to the exercise of the power of attorney that are subject to undue influence that was not due to the presumption. So it's kind of split temporally.
What remains, or what transactions would this be effective to that remain?
All of the transactions that were after the exercise of the power of attorney, which include many other financial transactions aside from the quitclaim deed, those are all part of what is being challenged by the appellee, in addition to financial transactions prior to the exercise of the power of attorney.
That does not arise from the exercise of the power of attorney, correct?
They're alleging that there was a separate undue influence that arose due to
There's an
him living there and her being
there's an
dependent.
overriding undue influence claim, but there's a specific power of attorney undue influence claim.
That temporally, gave rise to the presumption for purposes of the quitclaim deed and for purposes of other transactions that occurred after the power of attorney was exercised.
Now, you're aware that Carl was not a probate case, right?
Well, regardless of whether it was a probate case or not, Your Honor, I respectfully submit it was similar in so many fashions.
Because it involved undue influence and a number of claims.
And the power of attorney, and that's correct, Your Honor. The claims that were piecemealed, and potentially the trial court would have to examine the same evidence on partial summary judgment and at trial concerning the fairness of the transaction, and conceivably this court could also.
So if you're right that there should not have been a Rule 54 certification, then we would vacate the partial summary judgment without reaching any merits and just send it all back to get a final judgment at the end. Is that right?
It would result in a lack of subject matter jurisdiction, Your Honor, and it would have to be remanded and would have to move along in the trial court. Yes, Your Honor.
All right.
That wouldn't require setting aside the partial summary judgment, would it?
I don't believe it would, Your Honor. I think it would be remanded, and that partial summary judgment order would remain in place. It just wouldn't be a final order.
Let me just ask you a question about that. Did you file counter statements of undisputed material fact?
Yes, Your Honor.
We haven't gotten into the record yet, so did you raise this family agreement issue?
It is all in the memorandum. It is all in the affidavits. It is in the statement of facts. It is in the response to the motion for summary judgment. Yes, Your Honor.
All right, thank you. Thank you, counsel. We will take this matter under advisement and attempt to get you an opinion at the earliest possible time. You may